Today I'm here with Dan Hinchey. He is an attorney that specializes in probate and estate planning. And why I brought him on, I mean, it might not directly have anything to do with real estate, but it has a lot to do with passing on your home to your heirs or children. A large segment of my business is dealing with people who are retiring and getting to that point in life. And I deal with these issues a lot, and I thought Dan might be a great resource for my clients. So, Dan, why don't you tell us a little bit about yourself?
Thanks, Kevin. So, I started way back as a financial planner, and I really liked the role, but I felt it was somewhat limited. There was only so much that I could really offer. So, I liked the role so much, but I wanted to continue on, so I actually went to law school so I could focus on estate planning and then go back out, offer my
That's
clients
awesome.
estate planning, financial planning, so a little bit more under one roof.
Okay, that's great. And you're located right here in Haverhill.
Right in Haverhill, Harbor
You're in
Place.
the,
Yep.
the same building as my office.
Yeah. A few different names. The Wilworth Building, the UMass Lowell Building, Harbor Place. But yeah, 2 Merrimack Street.
Okay, excellent. Let's start off by asking you, what is estate planning?
So estate planning really is getting your affairs in order so you streamline the process for either death or incapacity, passing your assets along to the next generation or your loved ones, if you will, with limited court involvement.
Okay, so when you say court involvement, we're usually talking about probate.
Yes, a lot of people
Okay.
think, either I'll get to it or it's no big deal, it'll work out. It really doesn't. You need to do some proactive planning to minimize the court involvement, the expense, the delay before getting your assets to that next generation. Estate planning can take that a long way.
Yeah, and so, probate can be costly and time consuming and can be avoided in some cases. Am I correct in saying that, Dan?
Yeah, no doubt about it, especially when you're dealing with real estate. Real estate takes a
Okay.
lot of work to clear through probate, so I often recommend, and not to get ahead too far, but trust planning to avoid that whole court involvement versus,
Yeah,
getting
and
one of your successful plans.
recently I've been through it myself, and while I had an understanding of it before, I really have an understanding of it now. And there's some simple things that can be done that can help pass that home on. One of the things we're going to talk about is cost basis in a little bit, so we'll hold off on that, and that's really important. And then several years ago, I did have a client whose their father had passed away, and they had a house, and because it wasn't probably handled properly, they had to end up selling the house, and all the proceeds went to the state because he was in a nursing home. And
Yeah.
with proper estate planning, you might be able to avoid some of that. Am I
Yeah,
correct
I
in
mean,
saying that?
sometimes there's, and again, we don't have a crystal ball. We don't know what the future is going to hold. But doing the planning, almost always you're going to come out well ahead. Again, real estate's super critical, and a lot of times, Kevin, you see, husband and wife, they own properties jointly. Frequently, the first to pass, there's nothing to clean up because it was already held jointly, and that leads
Mhm.
people to think it's not a big deal. And then on the
So,
second passing, without that
So
planning,
let's just, I just want to go back for a second here. When a husband and a wife automatically own a property with rights of survivorship or jointly, and I think the important thing people need to note, often when, like, say, an unmarried couple buys a home, they're tenants in common. And so tenants in common, the property splits, and the property, if someone passes away over here, the property goes to their heirs and the property goes to the other person heirs. But when there's a joint tenancy with rights of survivorship, it automatically passes to the other person. Am I
correct. And
correct?
that's
Okay.
another huge mistake people will make, where it's just maybe boyfriend, girlfriend. They buy a property together and they own it as tenants in common versus joint with rights of survivorship, which they probably intended to.
And as an unmarried couple, they can own it with rights of survivorship. Am I
Correct.
correct?
Yeah, absolutely. So a
Yeah.
huge
Okay.
mistake that people make. They don't realize that they say, well, we bought this house together, so I get it all. No, you definitely don't if it's tenants in common, especially if you're not
Yeah.
married.
No. And most closing attorneys automatically put tenants in common with, and
Yeah,
they
I
don't
see
really
that.
have that
When people buy
discussion.
it straight from a builder or something like that, even married couple, they'll own
Yeah.
it as tenants in common, which is a huge mistake, and people don't know. They don't use a closing attorney. Things get screwed up. They don't realize until after the fact when someone passes that it's a huge mess.
Correct. So let's go to our next question, is because I think this plays a part in some of the estate planning. We already talked about probate, and probate can obviously take time and eat up some profits in the house. I mean, you're going to have to hire an attorney to go through probate. It's not something you can really do by yourself. And then there's going to be fees involved in going through probate. So the other thing that people need to be aware of is capital gains. And with proper estate planning, well, first let's talk about what capital gains are, and then let's talk about how you can minimize that to pass on the home to your heirs. And, when we're talking, most people, their home is probably one of their largest assets when they're passing it.
Absolutely. And sometimes
their assets to their
owned a property for 10 years, 20 years, 30 years. Properties have all gone up across the board, as I'm sure you know. So if, John buys a house in the 70s for 20,000, if he can hold that to his end of life and say it's worth $1 million when he passes, his beneficiaries basically get that tax free. Sometimes you'll say, well, I want to see my kids enjoy it now while I'm alive. Big mistake if they give it away now, because the kids down the road will have a humongous unrealized gain that they didn't know about until they sell the property.
Yeah, we're going to talk about that too in a little bit, because it's something I see a lot, but we'll tap into that. So what are capital gains?
So capital gains, again, you have as an individual up to $250,000 in capital gain that you can sell the place, and above that, that's your capital gain, right? Married couple up to $500,000. So you buy a place for $300,000, you sell it for $800,000. That's basically tax free to you. North of that $500,000 gain, taxable gain, not the worst problem to have. But again, if you can keep that property till your end of days, till you pass away, your heirs get that full step up in basis, totally tax free to the heirs.
Okay. So you use a term that, and again, unless you've probably been through this, you might not understand. And this is where estate planning can really help out, is the step-up basis. Yeah. So can you tell us what the step-up basis is? Maybe elaborate on that a little bit more?
Yeah, so exactly. So let's say, John and Mary own a home. They paid years ago $100,000 for it. If John passes, Mary just stays in the home, no problem there. If she goes and say, well, I'd like to see my grandkids own this house, my kids own this house, I'll give it to them now. That keeps that cost basis, a big mistake. Versus if Mary can keep that till she passes away, it ends up with the date of death value. So day one, when the kids sell it, it's completely tax free. Versus having that gain embedded in there. If they say, well, I want the kids to have it now, I want to see them enjoy it, let's give it away. It has a lower cost basis. So when they say, yeah, thanks, Mom, but we're going to sell it off and enjoy the proceeds, they have a big taxable event where they otherwise wouldn't if they had planned properly.
Okay, let me just circle back around on that, maybe to help clarify this. So you've got the cost basis, which is basically what the home cost you, purchase price, and then any capital improvements you might make. That would be your cost basis. The step-up basis is actually what the house is worth when that person passes away.
Correct.
That's passing the house on.
Exactly.
I think that,
so the IRS gives you that nice opportunity to step that up to that date of death value versus keeping that original cost basis. So a huge benefit if you can keep that house.
And so estate planning is very key in how you handle your estate. Can definitely make a difference in that step-up basis.
Even just having the conversation
we'll talk
to
about
avoid
some
that mistake
scenarios
of giving the place away too soon. Certainly you want to avoid probate, but even the tax consequences of action versus no action, a lot of times people will make a mistake because of positive action that they've done.
Yes. So now let's talk about wills and trusts. Those are probably some of the bigger things. And there's other ways to handle things, but what's the difference between a will and a trust?
Big difference there. A lot of people make the mistake of saying, all right, I have a will. This is so wonderful. I don't have to go through probate. I've written down who gets my stuff. It doesn't really work that way. A will goes through probate. The probate court probates wills. People don't know.
So I just want to stop you there. This is really important. It's a question I get asked all the time, and often when it's too late. A will, even if you pass the home on to your children or any asset for that matter, in a will, it still needs to be probated.
Exactly. People don't realize that.
Yeah, they think, okay, I can just go.
Want to get out of your estate plan. Oh, I just want a will. How much is a simple will? Well, do you own real estate? What is the point of that will? I want to avoid probate. All right, well, you're asking the wrong question because that's not going to avoid probate. That's going right to the probate court. So, to answer your question about trust, the trust stays out of probate court. But again, it's only the assets that you put into that trust. Okay. I've had people walk into the office, they have this beautiful document, and I basically say, well, what's in your trust? And they look at me like it's a strange question. Nothing is actually in the trust. Nothing was ever funded. You have to proactively add assets to that trust for it to matter. So any assets in your trust avoid the probate court. Any assets outside of that, if they're in your name only, are going head on into the probate court. Will
Okay.
or no will.
Now, we won't go real deep into this, but there are many different types of trusts, correct?
Yes. Yeah. I
And
mean, the
not
ones I
all of
see
them will
most frequently.
accomplish eliminating capital gains or minimizing capital gains and some other things. So it's really important to have a discussion with your estate planning attorney to find out what suits your needs and goals.
Exactly. Yeah. I mean, and frequently it's just, I want a revocable living trust and I just want to put my house into it. That's what I recommend frequently because that's going to be a large probate asset without any action. So create the
Okay.
trust, redeed the house into that trust. The trust is then funded. Probate for that asset avoided.
Now, again, I'm not an expert at this. My understanding is a revocable trust and an irrevocable trust handles capital gains differently
It depends.
on
A
how it's
revocable
written.
trust is largely an extension of you. So, Kevin, if you put your house into that revocable trust, a year from now you pass away, it would be the same tax treatment if you had not done that trust planning.
Okay.
Probate avoided, yes, but taxable capital gains, similar story. Irrevocable trust, it depends on how it's set up. You can, if properly set up, keep that tax structure. So you can
Okay.
avoid that tax problem that we talked about earlier, but it still can fall under IRS scrutiny where you have to defend it, and that also can be a chore. So
Okay.
oftentimes people want the irrevocable trust because they're worried about nursing homes and losing that
Hmm.
asset to nursing home costs.
So that actually brings me to my next question was is I should say, sorry, I'm looking at my screen here. Will setting up an estate help protect assets from Medicaid? And maybe just discuss a little bit about what could happen, the look back period and all of that.
Yeah, sure. So a lot of times people want the magic formula, right? I want full control over my assets. I want to avoid probate. I want to get everything to the kids. I want the state to pick up my long-term care costs. And that doesn't really exist. Long-term care is very expensive. The states are very smart. Mass Health isn't just going to say, all right, we know you're worth 10 million, but we'll go ahead and pick up the tab. So things will be scrutinized. Now you can do some planning, basically to get those assets out of your estate and no longer subject to Mass Health and estate recapture. But there is a 5-year look back, so you do have to proactively plan. And there's also some risks there. If I put my home in an irrevocable trust, it's not really my home anymore. So let's say I put
Correct.
it in an irrevocable trust for the benefit of my kids. They sell it off, they get divorced, creditor issues. I could lose that house that I thought I was going to be living in. So there are some real downsides.
And again, we're just touching on some basics here. And I can't stress enough if you're in a situation where you need to talk to an estate planner, definitely ask questions and let them lead what's going on.
Yeah, I mean, and again, Kevin, a lot of times people say, all right, since I've done this revocable trust, I'm okay for nursing home, right? No, it's not protected at all. It's still exposed. And Kevin's revocable trust, that's an extension of Kevin. Doesn't protect you if you have dementia tomorrow, but it does protect you in that you have full control over your trust.
We've already touched upon this, but again, I just want to call it out. If you have a will, do your assets need to go through probate, specifically your house? Because I definitely have had people come to me and say, can you list my home? I inherited it. And I'm like, whoa, 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 whoa. Have we gone through probate? Do you have permission to sell it? Have you started the process? Have you talked? And sometimes they say no. And I'm like, well,
Yeah.
you need to talk to a probate attorney.
Yeah, sometimes we'll see that where, mom and dad died. I just stayed in the house. I just kept paying the bills, never did anything, but now I want to sell. So how do I do that? Well, you have to go back and probate the last estate. And it's a
Okay.
real chore years later. So people don't
And
know
so
that
why
until
don't
it's
you
late.
tell us what is the purpose of probate? Probate just makes sure that the home is going to who it needs to go to, and
Exactly.
also to make sure there's no creditors that were against the
Very
estate,
true. It
correct?
gives creditors the opportunity to file claims against the estate. Oftentimes, what I'll see most frequently, anyone who's had mass health over the course of their lifetime, if they have a substantial probate estate, mass health will file a claim against the estate looking for reimbursement. So oftentimes people say, well, this is great. I'm going to inherit X number of dollars. Before you know it, Mass Health comes in with a $75,000 claim, and people say, well, do I have to pay that? I probably shouldn't have to pay that. They're the first ones in line. So, yes, but people don't realize that during your lifetime, their Mass Health is keeping track.
So I have when and why should you use a living trust? I guess the next question.
I think, again, Kevin, especially for real estate, but anything individually owned, more so for real estate. Kevin's house that he owns by himself. If you don't act, even including a will, if you say, all right, I'm going to give it to my friend at my passing, that goes through probate. With a
Yeah.
living trust, you can say, I want to go to my buddy. Day one, he can go and do whatever, sell the place out, move, renovate, doesn't need court intervention. A much cheaper and smoother way to pass assets along.
So in a recent case for myself, my mother had passed away, and there was some property that other than their primary residence that passed to my brothers and I. We, my parents had set up an irrevocable living trust, and the properties just automatically passed to us, and they were rental properties, Airbnb, and like the day my mother passed away, I had renters on the phone belly aching, and I'm just like, I'm getting rid of these. I can't deal with this. Mom had the time to deal with it. I don't. But that was the great part. Was I called up the attorney, and she says, you're pretty much free and clear to stick a sign in front of that house.
Kudos to her for doing that planning. A lot of people don't, or even the next generation doesn't appreciate when people do that sort of planning, how much money and time they've saved them.
Yeah.
And at the same time, conversely, when someone is named as the personal representative, it's not a great honor. It's a great chore if you haven't planned well. It becomes a full-time job when, hey, great, I didn't know what I'm doing. Now I'm someone's personal representative. I have to go and clean up the estate, get these beneficiaries their payments. Everyone's asking me for money. It can be a real problem. So if you do that good estate plan, so much easier.
My parents had set this up 30 years ago. They'd set a bunch of things up, and I was scratching my head at the time of why they were doing what they were doing. But going through it, I'm just like, I get it now.
Kudos to you, Mom and Dad.
So they were very, 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 I'm like, thank you, Mom.
Yeah, right. No doubt about it. She saved you a ton of time and headache.
Yeah.
And that's one of
another scenario that I run.
People who have large, gigantic estates, heavy net worth, still can have very, very small probate, very little to clean up. And at the other end, you could have a very meager estate, $50,000 net worth, and it's a full-on probate. So even sometimes we'll say, well, I don't need to do any planning. I don't have a whole lot. Above 25,000, and it's going to be a full probate intervention, and it's a pain for someone. So even smaller net worth folks, still worthwhile to at least have the conversation.
So another mistake that I run into quite a bit, I go to list a home and come to find out, mom and dad had added their kids to the property. And so there's a bunch of issues there that we should probably talk. But, so first of all, that means you don't have complete control over your property. You have to answer to everybody else on the deed.
Yeah.
And then secondly, we're talking about the cost basis situation where the cost basis really goes back to the original purchase price, not the step up price. But why don't you touch upon that a little bit?
Yeah. I mean, and oftentimes people say, well, if I want to put my daughter on my deed, just in case something happens to me, it passes to her by rights of survivorship. Again, a better way to go really is to fund a living trust with that property, and then you can name that daughter as beneficiary. You do muddy the waters if you say, all right, I'm going to share it with my daughter. Something happens to her. She gets a divorce. She has creditor issues. That house could be in jeopardy at that point. So I would always recommend keep that living trust. She can be successor trustee, full beneficiary. Day one after you pass, the daughter can go in and do whatever she wants. But adding a joint owner,
there's some scenarios.
Avoid probate when you pass, but tax-wise it could be worse. And then even creditor risks could be a lot worse.
So there are some scenarios where someone has had a house for 30 or 40 years. They might have paid $180,000 for it, and it could be worth, $1.1 million. I do see scenarios like that. And if the estate isn't handled properly, and is passed on to the heirs, you now have the original step-up basis, or you have the original cost basis of 180, and then when they go to sell the house, there could be capital gains of $800,000. And, that could be upwards of $160,000 tax bill.
So typically you'd at least get a split step up. So the original 50% owner would get half a step up. But still, doing that instead of just keeping it yourself, it went from a big tax bill versus no tax bill. So again, keep that in your own living trust. You get all the tax benefits in the world. Adding a joint owner, yes, it avoids probate, but it can lead to some other problems, including unrealized taxable gains when you go to sell.
To wrap that up. Don't just gift your kids to the house. Don't just gift your house to the kids now. And secondly, don't think adding them to the deed is going to, that's essentially gifting it. But,
Right.
you can look at it two different ways.
Yeah, definitely some downside there.
And so we're in Massachusetts. And if I'm wrong, when we're talking about gifting the equity of a house, the federal government has a large gift exemption. But the Massachusetts is only about $1 million, isn't it?
No, Massachusetts has no gift tax. There's an estate tax.
Oh, they don't. Okay.
Right. So federal, gigantic.
I'm talking gift tax when you gift something.
Yeah, Massachusetts does not have a gift tax. So you could gift.
Oh, they don't.
You could give $5 million today, not a problem at all. On the federal side, not taxable due, but you're supposed to file a informational gift tax return.
Yeah, but it's also, isn't that like a $12 million exemption on gifts?
I'm sorry,
a lifetime. 12 million federal lifetime?
It's north of 13 million now.
Okay.
So huge.
Okay.
So not a lot of people run into that problem.
But depending on what state you're in, some states do have very low thresholds for the gift tax.
Yeah. I mean, in Massachusetts, definitely has an estate tax. And that comes up often, especially with home values being what they are. Home equity, I mean, not even, home equity, 401k, a few other things, all of a sudden you're well north of 2 million, and people are surprised by that.
So let's talk about a life estate. I do run into that a lot.
Mm-hmm.
And that does solve some problems in that. I'm thinking maybe if your home is your only asset, that might not be a bad way to go. But what's your thoughts on that?
Yeah, I mean, that's a good question. Sometimes I see it and it seems to work very well. Again, there's probably some tax benefits you lose out on. But again, if you're worried about, long-term care costs, if I'm 90 years old, I could say, well, you know what, I'm worried about losing all the equity in this home. I may have dementia next week. Why don't I keep myself a life estate, which is going to be, the value of it's going to be based on your age. So obviously your life expectancy at 90, not hugely significant. So that value is not enormous versus the value of the remainderment. But it allows you to stay in the house for as long as you live. So not the worst option as well.
So the downside, when you do the big downside of, like, say, a life estate or adding your kids to the deed, again, is you've lost control of the property. If you want to mortgage the property, if you want to do any renovations, I mean, everybody has to have buy-in.
Yeah.
And you really need to trust your children. And the other thing you need to be aware of, your children's bad money habits could affect your ownership in the house.
Well, you should be okay as the life tenant, but there's also the tax consequences, slightly adverse there too, because you're basically giving away right now a large value with the remainder piece. You have the life estate. You're allowed to do whatever you want while you're there. But, there is risk there that, I go into a nursing home. I've lost some value, but at the same time, people that are 90, they've owned this house for 50 years. They paid $20,000 for it. If they just stuck around the house until they passed away, full step up for the beneficiaries.
And then,
I still prefer a living trust. You still have all the authority in the world. But
I think we answered the next question, which is, if a client came to you today, they're in their fees, their assets are primarily, let's say, $500,000 in equity in their home and $400,000 in, like, say, cash retirement assets, and they have two children they're worried about passing the most value to them, I think you will answer a living trust, correct?
Yeah.
That's what you would recommend?
Yeah, either joint trust if it's two of them. I mean, again, if you're talking about basically $1 million combined estate, not worried about mass estate taxes right now, certainly not federal. So have a joint trust, fund that trust with your real estate, and then anything else that you own, just make sure there's a mechanism to transfer it outside of probate, such as your IRA or 401k. That should have named beneficiaries and make sure they're up to date. Seen some horror stories there. But let's say you have, some people like to have separate finances. I like to have my own checking account. My wife has a checking account.
Yeah.
That doesn't pass to your spouse automatically. So at least go to the bank and name a payable on death beneficiary so you avoid probate for that asset, which should avoid probate. But you see some really bad planning mistakes there. Yeah.
And, so I've obviously been involved in this for a very long time as a real estate agent. And given a large part of my business is in that age demographic, I see a ton of mistakes that people have made. One of the biggest mistakes is just procrastinating.
Oh, yeah.
You should do it as soon as you have children and you're worried about where your assets are going, even if you're, 39 years old. Nobody knows when the reaper comes, So that's one mistake. And then the other thing is waiting too long and it's just too late to get all of the benefit that you have from proper estate planning.
Yeah. Yeah. Two things there. I think oftentimes we do probate cleanup for people that they come in and John died unexpectedly. We didn't plan for this, and there's just no game plan at all. So it's just a real mess. The other being people that say, geez, my mom just passed. What a mess it was. I don't want that to happen to my kids. So let's get this done. And people frequently are in their 60s and 70s. They feel sheepish that they've never done this. But listen, you're alive and well now. You still have time. It's when you've passed,
Yeah.
then it's too late. So don't stress about it. We can get it done today.
Yeah.
You know?
Yeah. Absolutely. So, Dan, I want to thank you. Very, very informative. And it's a very complex topic. So I'll have Dan's information down below in the description here. And you can reach out to him if you're in a scenario that you would like to discuss what's going to happen with your estate. So, Dan, thank you. Thank you for all this great information.
You bet, Kevin. Thanks for having me.